My name's Roger. I'm from Portland, Oregon, and I'm here to introduce today's speaker. But before we get started, it is a live stream presentation, so welcome those of you who are attending virtually. And if you have questions, please use the NACM app to type in your questions. I will relay those questions to the presenter, Kevin Bowling. And to get started, today's session, just to make sure you're in the right place, is on NACM's core, the public trust and confidence, the challenges. And I have the honor of introducing today's presenter, Kevin Bowling. Kevin has 40 years experience in court administration, currently working as a trial court administrator and attorney referee in the Ottawa County, Michigan. He's a past president of NACM, currently a co-chair of the JTC, and the chair of the DOJ Global Advisory Committee, and a graduate of the NCSC Fellows Program and a NACM Core Champion. He also had the honor yesterday of being awarded with the Distinguished Service Award. So congratulations, Kevin. And I've had the pleasure of serving with Kevin for a number of years on the JTC, and he is a mentor to me, and you know, he's a fabulous person. So I'll turn it over to Kevin.
Hey. Thank you, Roger. Good afternoon, everyone. Thanks for taking time to come out at the end of the day and to still continue with your education. Some of you were in the room for our last session that I thought was a fabulous session on diversity, equity, and inclusion. And it gave me pause the farther we got into it, because I remember somebody telling me many, many years ago, it's much better to watch an anticlimax than to be one. So hopefully we won't run into that problem here today. As Roger mentioned, you're in the right place if you're here to have a conversation about the core section that deals with public trust and confidence in the courts. It's something that we all deal with, and as I say, all of us dealing with this, I really want this to be a conversation this afternoon. So just as fair warning to let you know, for the slides, I knew Roger liked numbers and likes data, so I went through just to give him a little data earlier. For our 75 minutes together, I have 25 slides, and 32% of those slides have questions for you. Those of you here in the room and those of you that are on the live stream. I'm also watching some of our ICM mentors who are in the back, who are probably wondering if I'm traveling around that circle that Michael Roosevelt was talking about in the last session and doing something interactive. So we are going to do some things interactive, and a lot of that's going to be your Q&A with me as we go along. So hopefully you're ready to buckle up, have a good time as we go through this. I was also asked to mention, for those of you that are not familiar with it, the Core Champion program. It is described on in the NACM app. For those of you that are interested in that program, there's an application where you can sign up for it, and you can get some credit for this session if that's something you're interested in pursuing. So please look for that information on the app itself. The other thing I wanted to mention before we jump into this, I was first asked a couple of years ago to talk about public trust and confidence and the new core application of it a couple of years ago at a NACM conference, and this year we're looking at it a little bit differently. As you can see on the cover slide, it's talking about the challenges. Many of the challenges that we're facing that we're going to get to later in this presentation we'll be talking about, but how has things like the insurrection at the Capitol on January 6th, or the George Floyd case, or the pandemic, or other challenges that I may ask you to identify that you've seen in your own court, how has that affected public trust and confidence in the courts? And what is it that we can do to improve that situation for us? When we think about this competency that we'll see in a moment as just one of many, we have to, I think, keep in mind that this session was originally developed for a 15-hour course, and we're doing it in a little over an hour. So we're going to fast forward through a lot of pieces of it, but again, I hope you will engage with me as we go along. So let me just jump right into it. Again, we're trying to look at this core and tie it into the overall theme of the conference of Justice for All, Courts at the Crossroads. Keep in mind that public trust and confidence is one of 13 competencies that we're all familiar with, or getting to be familiar with. But it happens to be in the principal module where there are just 2 competencies. And this is part of what we're thinking of. It needs to be a foundational piece for all court managers. And I would suggest to you that we all could take this material home and use it with all of our staff. It doesn't have to be limited to court managers or court administrators or court executives. Everybody that works in the courts has some role to play in developing public trust and confidence in the courts. So I hope you take that to heart and use that to your advantage in your own jurisdictions as you go forward. And we can see how that fits in with the rest of the core itself. Well, let's see if we can back up here a little bit. There we go. One of the things I wanted to mention, whether you're looking at public trust and confidence in the courts or any of the competencies, when the core was developed, there were a number of things that were built into the curriculum design for all of the competencies. And again, some of you may be very familiar with this, but there are learning objectives, things that we're trying to accomplish as we go through, and you'll see some of those identified on some of the future slides. There's needs assessments that are built in. Why is this important? Why are we doing it? What do we need to focus on? There's obviously the educational content that is baked into all of the competencies as you go along. And there are participant activities. The other thing we're always looking for through NACM is folks like you, leaders in the courts, people that can pick up this material and use it for additional training in your own jurisdictions. And for that purpose, you'll find faculty resources that are baked into the entire core. So if you go through and look at the curriculum that's laid out there, it's laid out in such a way that any of you could pick this up and teach it in your own jurisdiction. And I hope if you've never thought about doing that before, that you consider that possibility. Or team teach it with someone if you're not comfortable doing it yourself. But think about bringing it back, and you'll also find a bibliography and lots of other resources that are available for you. If any of you are interested in a short course and you just want to take the materials that I have here today, let me know. I'll freely give them to you. None of this should be considered a secret or a treasure that we keep hidden under a rock or under a basket. We want to get this information out to everybody in the judicial system. And we want to make sure that we do whatever we can do to sort of raise that sense of public trust and confidence in the courts. I was a little disturbed in an earlier session today. It was a great session that ILES provided some information on survey results. I see our presenter back here smiling as I say that. Brittany, thank you for that great presentation. But the data that they showed in that presentation was scary in some respects, in that we in the courts have a challenge or several challenges ahead of us in terms of developing an improved public trust and confidence in the courts. So I think as you watch for some more of the data and the work that's coming out of ILES and other organizations that are interested in this area, you'll find that helpful, I hope, as we're going along, and it will get us to the point where we can do a better job. So again, tying back the core to the conference itself and looking at challenges, part of what I've included in the materials here are a few challenges that came to my mind pretty easily after Jude approached me and asked me if I would put together a program for this. but things that immediately jumped out as challenges to public trust and confidence in our court system today include things like the pandemic. So what did we have to do? In a lot of our states, we had to shut down. We had to close the doors. That's not going to do a lot for public trust and confidence in the courts. If people have legal issues they have to deal with, what are we going to do about that? And in many of our situations, we pivoted pretty quickly, and we figured out ways to keep the court system open, operating, and moving forward. I don't know what it's like in your jurisdictions. We kept a lot of ours cases moving. The biggest problem we had were criminal jury trials, where just because of state health department regulations, we were basically shut down, and we couldn't bring jurors in, and it made it a little more difficult, and there wasn't a groundswell of movement as there were perhaps in some other jurisdictions of going to remote or virtual jury trials. We also have things about racial injustice. The last session was talking about that, and we'll focus on that a little bit more. But this is, in our country today, we've got these issues that are facing us, and it's not just the courts, it's a lot of public institutions that are under fire, and that has a direct impact on how people perceive who we are in the courts, what we do, and how valuable we are. And obviously that affects the public trust and confidence. We saw election challenges. Some people would suggest that, well, maybe that doesn't need to have to be a challenge for us, but I know in my home state of Michigan, a lot of election conflict comes into the courts. If there is a problem, where do they go for a resolution? And it's to us. Misinformation is a challenge, and attacks on the rule of law are challenges. What I put in here is a number of websites or links that will take you to information on all of these challenges, and I hope you take a look at them at some point and think about what does that mean in your jurisdiction. And then for my first question for you, I told you none of you are going to get off the hook today, is what other challenges are there? Are there challenges to public trust and confidence that you're seeing in your courts right now? And I'm going to invite the folks that are on the live stream to share in the chat, and Roger will let us know about that. If any of you have challenges, we have microphones up here. I'd invite you to come up, just since we're being recorded and live streamed, you could share that. But what are the other challenges, if any, that are you seeing in your courts? And this would be the interactive part. So don't be bashful. I don't bite. Come on up. Who has seen other challenges? Let's make sure the mic is on.
It's the ignorance of the media in describing how the court performs its duties.
Say that one more time.
It's the ignorance of the media in how the court performs its functions.
Are there others?
I think since we had a year and a half, thank you. Since we've had a year and a half of really great experience in the remote virtual world for our court closed March 23rd, 2020, and we reopened May 10th of this year. And the only thing that we couldn't do was have jury trials and grand jury, and that's because our state Supreme Court emergency orders prohibited that. So we really nailed everything else, from protective orders to every other, I even held a mini adoption day. So the challenge I see is maintaining that level of efficiency, especially because we had some judges that did not necessarily participate in the virtual scenario. And, if you're of a certain generation and you were oriented a certain way and you just didn't want to make that shift. And so now that we're coming back in and we held our first in-person trials 2 weeks ago for the first time, it's like a new job for everybody.
Yeah.
But the public has gotten used to being able, and attorneys, to be able to be flexible around hybrid schedules. People have gotten used to not having to take off from work to come to court. And so the challenge is, let's continue this. Let's not go back. We had a contactless paper process, and it worked beautifully. Along the way, we made enhancements. We do queue-based workflows. And so we are not going to change that. And so some, though, want paper please. It doesn't exist anymore. So the challenge is getting people to maintain the lessons learned from the past year and a half.
Great example, Deborah. Thank you for that. And I hope, yes, we have another one right over here. Feel free to come on up. Or
One of the, hello?
slide the switch up.
Can everybody hear me? So one of the challenges for us is the fact that we have input all those efficiencies, and there were different decisions made temporarily for, let's say, pro se or prosecutors, defense attorneys to email things to keep social distancing. They don't have to come to the court. And so everyone's wanting now to skirt around court rules, and why can't we just do this? And it's trying, you know, it's like, it's been a challenge to still instill that there are procedures in which processes must be done, and now everybody wants to cut through those procedures because it's just more efficient. Why can't we just do this? Because, you know, you allowed it at the beginning. So it's trying to get back to still wanting to be efficient, but still needing to follow the policies and procedures that were in place.
Great
So-
example. Yes, it's in some ways, how many parents are out there? Got kids out there? How many of you had wailing and gnashing of teeth if you had the training wheels that you took off and tried to put them back on again? You know, that probably would not go well in your household. So in some ways, that's what we're doing in that situation. You know, for the pandemic, we just said, okay, we've got challenges. We've got to keep operating. Let's take the training wheels off and do what we have to do. And now we're trying to figure out, well, do we go back? And maybe that's not the best situation. So great example. Thank you for that. So as we go forward, one of the things that you're going to notice in this curriculum itself for public trust and confidence, as you look at the core, there are 7 sections that are built out in there. The first one is just simply an overview, and it will give you some ideas about it. But as I looked at this material again, it made me think of a lot more questions for you. And I warned you that I was going to ask you a lot of questions. So these are just some of them that I'd like you to consider. If anyone would like to jump up and answer any of them, feel free to do that. But what does public trust and confidence in the courts mean to you? Why should we care about that? Who needs to have that trust and confidence? Why is it important? How do we know if it's there? What do we do, or how do we lose that public trust and confidence? Which is a question that I hadn't really given a lot of thought to before, but I think especially in our given circumstances today, we have to think about. And then perhaps most importantly, and again, you know, stealing a line from the ISLES presentation earlier today, they talked about ISLES being a think tank, but as they talked about it, they said, no, we want to be a think and do tank. And sometimes in the courts, we have to be thoughtful, we have to be reflective about what we're doing, but we also have to figure out how we're going to do things, how we're going to move forward, and what do we have to do. So somebody help me out here in the crowd. Who wants to take a shot at why this public trust and confidence issue is even important. Who can share a little bit about what your thoughts are there? Anyone? All right.
Well, it's a clear separation. We have to be clear about.
Yeah. No? We'll go here, and then we'll go over to Deborah.
Sorry. Lillian Hawkins with Washington State.
Thank you,
Well, we
Lillian.
have to have a clear separation of powers. The judicial branch is separate. We have to make sure that that is clear, that we are fair, impartial, and equitable, and we should not be blurring the lines with the prosecutor, defense, or law enforcement. So that's why it is extremely important.
All right. Thank you. Deborah.
And since the justice system has such an impact on our community, especially take, for example, this whole election cycle that has ended up in courts, and there's a segment of the population who don't believe anything that comes out of a court or a judge or an entire justice system. So it is important, and that's an example of why we have to maintain the rules, the policies, processes, and just the perception of the court being even slightly unfair, inequitable, has a significant impact on people's lives, and even the respect for the rule of law. And so as we change and migrate different processes and service delivery modes, it's important that the public feel confident in sending a birth certificate via an electronic method or receiving a child support order on their phone. Is it real? You know, and so the public trust and the perception of the court and our justice system is so important because of the impact it has on the lives of so many people and our community as a whole.
Great comment. Thank you for that, Deborah. Now, how about if we drill down just a little bit more on these questions? Oh, we have one, Roger, from...
Yes, Michelle online says, the integrity of the court. The integrity of a court is at stake.
All right. Thank you. So let's go a step further before we jump farther into this. What are any of you doing in your jurisdictions, looking at the last question on the screen, to build public trust and confidence in your courts? Whether you do it directly, indirectly, who's doing something in one of your jurisdictions?
You know, I think it's related to the comment up here about the media. You know, we work in pretrial services, and so questions about bail, you know, and what's a fair. There's a lot of criticism if someone gets, you know, released during the pretrial phase of the court process.
Absolutely.
And there's criticism that comes in, or there's a news story. I think we try to do a good job of messaging. You know, so we don't want the media to create the message. We want to create the message as to why this individual received a fair decision at their initial hearing. And we feel that that's the best way we can better educate the public is through the media, and treat it as an opportunity rather than, you know, while they're picking up on this case. So well, let's use that to talk about why the court work is important in this area.
Great example, and I think in some ways that addresses directly what Paul was raising a little bit earlier in terms of some of the problems with misinformation in the media. You had a comment, sir.
I'm with Maricopa County Superior Court in Phoenix, and what we've just done, it just started 2 weeks ago, is we've always had court PIOs that respond to media inquiries, but we were revamping that, and we've hired a communications director. So rather than just responding to media, we've hired somebody that came from actually our State Department of Transportation to start working more towards marketing campaigns and community outreach and being more proactive rather than reactive. And so he's working. We hired someone whose expertise in really building communication plans that involved networking, getting us out in the community with community groups, and starting a speaking system with our judges, and so just really revamping our whole entire communication strategy to be proactive rather than reactive.
Great example. Thank you for that. Do we have, Roger, there are a couple of other hands over there.
So for the question, what can we do to build public trust and confidence in the courts, is we have to rethink and remember who we serve. A lot of times the decisions that we make, it's based on the judge and the attorneys. Very seldom is it the court user. And so I think we have to change our perspective and focus on the people that we serve. We also need to make sure that our frontline teams, that they take the time to listen to people and not just create this robot environment, but take the time, let people tell you their story before you try to formulate an answer.
Absolutely. Thank you for that. And I think we've got one more here.
I was going to say that one of the things, is this working? One of the things that we do in Washington State is we have a Judges in the Classroom program, where our judges, we work on educating the children. They're going to bring it home to their parents, to the public. It's a public outreach item. So the judges go into the classroom and they talk about the separate branches of government. They have different curriculum that our administrative office of the courts has come up with. And through the education of the children, they're able to reach the public, and hopefully they're building some trust and confidence that way.
Fabulous example. And probably, oh, we have another one.
Yes,
Roger.
and Dave online says, conduct court user surveys, engage in strategic planning, and be transparent with your plan, and engage with the public via social media.
All right, so I'm going to thank Dave in a minute because it's a great segue into my next slide. But going back to the comment about the education, especially with young people, sometimes we may not think about the fact that we're doing work on public trust and confidence in the courts when we have typical programs that might be part of many of your jurisdictions. How many of you do some kind of Law Day activity or Constitution Day activity or some other outreach to local schools, or even if you just have a tour of students that come through the courthouse? Sometimes we have scouting groups or other local JC groups or something along those lines where kids will come in, or college classes may come through. Every time we do things like that, just like you pointed out, we are building that public trust and confidence, because then those kids are going to have a little better idea of what's going on in the courts, and are going to take that message home or take it and share it with friends or whomever. So, we just have to be conscious of the fact that we do have a role to play. And it's not just us as court managers or court leaders, but also our staff can do that very effectively. So another thing that is tied up in the curriculum itself, you'll see references to different kinds of surveys that are out there. There's an analysis of national survey of registered voters that answers a lot of questions and gives us information about the fact that courts, even though some of our trust and confidence may erode from time to time or through some of the challenges that we talked about, we're still the most trusted branch of government, according to many surveys that are out there today. Doesn't mean we don't have work to do, but it indicates that it's still strong. But there are worries about political environments that do undermine trust and confidence in the courts, and different issues that pop up that way. Many of you are familiar with the work that the National Center for State Courts has done repeatedly over the years, and you might have seen some of these State of the State Court surveys that look at public trust and confidence, specifically in the courts. There are several of these that are out there, but if you haven't seen it, one of the things I'd recommend you to take a look at is a podcast that they did, and they did this survey a little bit differently in 2020, where they talked about not just the state of the state courts, but the state of the state courts in a post-pandemic world. And in the materials that you can find on the app, there's a link that will take you right there, or you can find it on the National Center's website as well. But they talked about what's it going to look like when we reopen, and what are some of the issues there. The other thing I would encourage you to take a look at if you're interested in surveys or what people think about this. I know I've mentioned it before, but while Brittany's in the room, I'm going to continue to take her name in vain. From the Isles Institute at the University of Denver. They are working on these issues right now, and they have done some nationwide surveying, and they're going to be releasing a report in somewhere around Labor Day. Is that right? Okay, good, I got that right. But they also have other information about that, and one of the things on their Public Trust and Confidence initiative, they also had the foresight to reach out to court managers. And they have a couple of court managers or former court managers in that working group, including our own past president of NACM, Marcus Renkensmeyer. And then Alan Carlson is also part of that group. So there are a number of these surveys that are out and available to us for any of us that are looking at this issue of public trust and confidence. So as we think about managing and going forward, sometimes in this competency and other competencies, we may see ourselves looking in the rearview mirror and understanding that there's a historical basis for much of what we're talking about in this competency and in others as well. But when we look at public trust and confidence in the courts, some of these discussions go back a long way. I'm sure many of you have the words of the Magna Carta memorized or tattooed on you or hanging on your wall or something along those lines. But even back in 1215, that's when we started seeing the rule of law emerge. Why? Because there was no public trust and confidence in the system that was set up to handle disputes at that time. The idea was to create something that was going to work better. And since that time, we've seen a lot of other things. Many of us who have studied court administration in one form or another, you've read Federalist Papers, you've looked at some of the writings of some of the founding fathers of the country. Our Constitution deals with the establishment of the judicial branch, obviously. We also have heard at times about Roscoe Pound. Some of us even have PTSD when we think about going back, and I see a couple hands in the back. So I'm with you on the Roscoe Pound PTSD. But the reality is, back in 1906, he made a speech to the American Bar Association and saying, listen, folks, this court system isn't working. It's screwed up. We've got to make some changes. We've got to do something to improve public trust and confidence in the courts. So what we're talking about in this competency is not something new. This is something we've been dealing with for a long, long time, and we always have to keep it somewhere near the front of our minds as we're looking at operating our courts and wanting to move forward. There's a lot of information that you can see, again, in the materials and in the competency curriculum itself that goes back and looks at different kinds of standards, performance measures that have been developed for the courts. The thought behind including these with the competencies is simply because if we have some kind of dashboard, if we've got some way to measure what we're doing, if we can show the public that we are handling their business in an appropriate, reasonable way, then there's going to be, hopefully, an increase in public trust and confidence. I talked a little bit about those surveys. For many years, there were sort of like every decade, some major national group, whether it's the Hearst Corporation or Pew Charitable Trust or others, will do these different surveys. And you can dig into it and look at all kinds of data. But the thing that always strikes me is that if you boil it down, there seem to be three concerns that people have. Courts take too long, they're too costly, and they're too confusing. If we could solve those problems, that might help us improve our public trust and confidence in the courts. So these are some of the things that we have to think about when we look at the historical basis, but one of the points that I wondered about as I was thinking about coming here today is, what do we learn from recent events? And what impact does that have on public trust and confidence in the courts? You know, we've touched on those. You've heard about them throughout the week in other sessions. But just within the last year, we've got the World Health Organization declaring a pandemic. I don't remember the last time we had a pandemic to deal with as court managers. It hasn't been in my career. But that's an issue. We've had the situation of, with the death of George Floyd that also occurred last year, which has been a marker for many people to look at, but it shouldn't diminish the fact that we're looking at several of those situations. We're not looking at just one. This is something that's been going on for quite a long time, as the prior panel was discussing. And then we also have the January 6th event at the US Capitol. So as we look at the historical basis for public trust and confidence, we have to think about, what is it that these kinds of events will do? So let me ask you, have we learned anything about public trust and confidence from these events? Is there anything that we need to pay attention to or do differently as a result of events like this that work into the history? Another question for you. Who wants to take a shot at it? What have we learned, or what should we have learned from events like this?
That equal justice is important, and that people are no longer going to sit on the sidelines and wait.
Okay. So again, for our recording and for our live stream audience, Deborah, you know, equal justice is important. And folks are not going to sit on the sidelines and wait any longer for us to. So, important message. Any other messages come to mind that we need to pay attention to? All right. I won't. Deborah, you got a microphone right behind you.
I just want you to have any dead air.
All right. I don't mind. I'm a patient man.
What was I going to say?
Go.
That change can happen. Even positive change can happen when you integrate the justice system and public confidence.
Okay. And Roger, it looks like we have another one from our live stream audience.
Yes, we have two. Veronica says the importance of coup planning. And
Okay.
Norman says, we've learned that public trust is fragile and must be earned and sustained.
All right. So a couple of very good comments there. Thank you for those. And I'm glad our live stream audience is participating as well. So the reason I added this in, and it's not in the curriculum materials that you'll find online right now from NACM, but when we think about that historical basis for public trust and confidence in the courts, we can't just look only in the rearview mirror. We've got to think about where we are in our current situations and what's happening today that has an impact on us. So from here in the curriculum, as you go through it, we move into section 3, which looks at the impact of our court process. You know, what is it? The italics on the left side of the screen is actually from the learning objectives. And it talks about documenting ways that transparent and consistent application of court procedures, as well as timely resolution of cases, enhances public trust and confidence. So looking specifically at that, and this is the area where I think it goes beyond us as court managers, as court leaders. This is another example of where we can drill down with our staff. All of the people that we work with, our colleagues back in our courts, have a role to play in developing public trust and confidence in the courts. So what does that look like? How do we go there? And it could be, you know, when folks are coming in to file cases, or maybe in your courts, they don't file cases anymore by coming into the court. Maybe it's all electronic and they're coming in, but something in an e-filing system is going into a clerk review, and somebody's got to look at that and decide whether to accept it or reject it. If they reject it, how do they do that? You know, do they end up having a conversation with someone? Are they able to help them walk through a process so that they have a sense that their cases are being competently managed? And is that going to have a positive impact on their perception of the courts and who we are and what we do? Timeliness is always an area that we're looking at. We all are dealing with some kind of performance measures, no doubt, and time standards that we're trying to follow in terms of processing cases. And we may just think about that as another management issue or a management tool, but in reality, all of those things that we do to help people navigate the court system, to get their cases from the point of disposition or from filing to disposition and do it as effectively as possible, that has an impact on how people view us, how they view the courts, how they view whether they're going to get justice in the courts. So it's important as we go through and take a look at some of these. So obviously our process has changed. Get ready for the interactive part. It's the questions coming up. So what have we learned during the pandemic? You know, obviously a lot of our procedures don't look the same way they did a year and a half ago. So what impact or what have we learned from shifting to virtual hearings or to touchless interactions with the court? And how can we build on that? There's a microphone somewhere, Mark. Let's see if we can get one for you here.
That sometimes it takes a crisis to get something done that should have been done 10 years ago?
I think you got a lot of nods on that one. So, yeah. But what does that tell us about how we might be able to do things differently or perhaps be more proactive in the future when it comes to improving our operations?
Yeah, well, I think anybody who's worked in the courts for a long period of time, and probably the history that we tell ourselves all the time is that the court is a deliberative process of which takes a long period of time, and that you know, we have to think things through over and over again. We have to have rules and regulations fully in place, all of which honestly I agree with, but sometimes that's not always needed. And we did, I mean, I think this is probably true for a lot of people here. We did in probably less than 3 months what would have taken, like I said, 5, 10 years to do. So, I mean, we could do it if we wanted to do it. Mm-hmm. I just think that we have a set mind, or we have a mindset that says, no, that's not how we do it, because we do things differently. But I think it just taught us that we gotta figure out what are those things that we do still need to have in a deliberative process that we can't rush through, and what things do we really need to tell ourselves, no, for the service of the people that, or for the people that we serve on a regular basis, we need to do a better job.
Absolutely. Good point. I'm looking for any other hands, any other comments right now. Roger's got a mic coming right up to you.
That providing equal access to justice is really not all that difficult if you just put in a little effort.
I love it. Say that one more time, a little louder, please.
Providing equal access to justice is not that difficult if you put in a little effort.
Yeah, well, thank you for that. So it makes that point of, we do have some responsibility, and if we do put some effort into it, we can get great results out of it that people like and gravitate toward. We've made it a lot easier for people to access the court system in some ways, and I think many of them appreciate that, and some are nervous about that being taken away as we go back to the way we used to do business. Roger, it looks like you had another comment from our live stream audience.
Yes, Veronica says, we've learned we are adaptable.
We've learned we are adaptable. Great point. So, these are some things, we don't necessarily think about it in terms of our court process, but it really does have the ability to dramatically impact public trust and confidence in the courts. And that's something I think we have to keep in mind as court managers. Moving to section 4 of the curriculum, there's a discussion about the emergence and the application of procedural fairness. And this is a concept that I would guess many of us are familiar with. It's something that there's been a lot of research and a lot of writing on in judicial administration materials. But this is where we're looking at, if you look at the, again, part of the learning objectives here, to ascertain the level of public misperception about the courts and its causes. Where does some of this come from, and why is it difficult to get to the point where there's a sense of procedural fairness in the courts? And to drill down a little bit farther on that and look at the application, specifically what this is trying to get at, if you're not familiar with the concept, is these 4 areas of voice, neutrality, respectful treatment, and trustworthy authorities. Those are sort of the underpinnings of procedural fairness. So the voice is the ability to participate. Having that voice in the process, seeing what that's going to look like. When we had to change procedures, there was a lot of questions about whether that could be done virtually. Are we protecting people's constitutional rights? Do they still have the same ability to confront accusers if it's being done virtually versus in person? Are folks able to participate? If they don't have good broadband coverage in their area, does that cut their voice out of the system? The neutrality, looking at consistently applied legal principles. Again, that comes down to how we operate our individual courts and how our judges and judicial officers may treat folks when they're coming into the courtroom. The respectful treatment speaks for itself. It's something we've all tried to strive for in different ways. But again, this comes down to an example of why public trust and confidence in the courts is not just in the purview of the judges or us as court managers. It goes right down to the front line of folks that we have in the court staff. And some of you may have heard me mention this before, but it's my own trauma in the court environment. But I remember as a young person many, many years ago, shortly after getting a driver's license and finding out I really like to go fast, and that wasn't a good idea all the time because I'd have these funny flashing lights chasing me all over the place. I had to go to court once or twice. And there's one court, I'll leave the state out of it, it's not Michigan where I live now, but I think I gave that one away. Okay, I grew up in Rhode Island, so. But this court actually isn't there anymore. It's been torn down. But I walked in, and I can't make this stuff up. So I walked into this court, and I'm trying to deal with a court clerk. I was probably a mouthy teenager, but I was doing my best to be respectful. And I swear, this clerk was sitting at a desk with her back to me. And I don't know if any of you remember riding a school bus, but all the bus drivers and the school buses I rode in had this big rear view mirror. And They just, kept an eye on the bus. Well, in this court, in the clerk's office, the way this clerk addressed the public was to bark at them, never moved out of her chair, never turned around, never recognized me, but just sort of looked up in the rearview mirror and saw another pain-in-the-butt kid that was there to try to get something taken care of. And that was my experience with the court system. Now, I would suggest to you that that might have an impact on some people in terms of their public trust and confidence in the courts. If I saw somebody on my staff set up a rearview mirror over their desk and not turn around to wait on somebody or have a civil conversation with them, we'd be having a different kind of conversation. And my hunch is many of you would be doing the same thing. So it's those little things like that that can have a tremendous impact. Here, I'm 40 years later, I'm still traumatized by my experience. I'll never forget it. But from a court manager perspective, now I know that I have certain expectations for my staff as well, where I want to make sure that we're treating people respectfully, that we're treating them and meeting them where they are, where we're listening to them and trying to hear them out and understand what it is that they need. And that's going to help us with these expectations about procedural fairness as we go along. So, and then when we talk about responding to expectations that people have, I had a couple more questions for you. Is there something that we can or should do differently, and what are you doing in your jurisdictions? So I'll give you, well, not a minute, maybe a few seconds to think about that. But I'm curious, something I've always been aware of and appreciative of at NACM conferences is that a lot of the learning comes just from sharing ideas among each other. So what ideas do you have? What do you do in your jurisdictions that would cause people to feel like we're exceeding their expectations and helping them out? Is there anything in particular that goes on in your jurisdictions? Deborah, the mic is coming back.
Thank you, Kevin. One of the things, since all the contact with the courts, clerk's office, was all online.
Yes.
There was no phone, so you go to the website and there's a list of things that if you want to file, and then there's the contact button. So some people, in looking at all these areas to integrate and actually complete whatever process you want to complete, some just want to talk to somebody. And I think because not understanding it, or it was different for many people. And so there's just a contact area that you can just say, please call me, and someone will call you within minutes. And that kind of contact, because it can be daunting and people want their cases heard, their divorces final, and there's just a lot of, apprehension and uncertainty about, is this gonna really work? Are my documents going through? And just hearing a human voice goes a long way. And I get so many letters from the public that say, this person literally stayed on the phone with me and walked me through an e-file process. Or they actually call me back. I was surprised. When you send in something through a website, you don't expect it. But making that effort to have personal contact, human to human, went a long way.
Great example. I think we have one more over here, Roger. Or Janet, you've got that mic.
A couple of things we did is, first of all, we don't call them defendants at our court. They're in the courtroom, they're defendants. Outside of the courtroom, everything else, they're a court customer. And so we changed that perspective because it changed the way that our staff serve them if they're a customer versus a defendant. Small change, huge difference. The other thing is we changed the name of our probation department to Court Support Services because it has a less punitive connotation and it really lines up with the way that we do things, which is restorative justice. So just simple things like that, it changes the mentality of the service that we provide, because most of the time the public's trust and confidence, it lacks, and it's not because of necessarily what happens in the courtroom, but it's the way people are treated and served outside of the courtroom.
Yeah. And I think that's a fabulous example. I challenge you on one part of it. You said it was simple. I think you're talking about cultural changes in the court, which are anything but simple. And I give you gold stars for working through that. But all of us that have been through cultural changes of one sort or another in the court know that it can sometimes be very difficult to do that. And if you're looking at your own professional development, I'll just throw in a unsolicited plug for ICM right now, but in the ICM governance course, if you ever have a chance to take that, there's actually a section that deals with court culture. What it is, how you change it, how you can address it, how you can improve it. And it can be a very difficult thing to deal with. And if you want to look at some exercises about that at some point, there's also some writings that Dr. Brian Ostrom from the National Center, I think the research division, has written on that topic about court culture, how you can assess it, how you can identify it, how you can work at changing it. And I think you just raised a great example. And the whole restorative justice field is one of those areas where we've seen major culture changes in some jurisdictions. Another cultural change that many of us are familiar with that goes back to 1989, but it didn't catch on for a few years, is our problem-solving courts. That's another area where we can look at in many of our jurisdictions where there has been a significant cultural change. And sometimes we need to go in that direction. So, speaking of going, we've got another
Yeah, one of the things we did in our jurisdiction was worked with the judges and the police officers. And what we do is we allow them, when they have somebody in custody, to set aside that warrant on site through local court rule. So what they'll do is they'll call our office and say, hey, give me a new court date for one of our 15 judges. Or if it's a case that's in arraignment, we will then set that court date out. We'll work with the police officer and say, hey, when can they be here? And then we set that court warrant aside, push that off to the docket date. The ones will go up to the assignment to get up to whatever date that is and get set that way. So it's not something we advertise, but it gives the police an option not to take that defendant and put him in the jail.
Right. So again, you're helping out and you're making it that experience in the court a little bit better for individuals. Margaret.
Hi, I'm Margaret Allen Hoyt from ICM at the National Center, and just wanted to mention on this topic of procedural fairness, we have a free online course. It's both for judicial officers and for court personnel on the topic of procedural fairness. It takes about an hour. And so I'm going to make this commitment to the streaming audience here. We also have a facilitator guide and a participant guide. So it is a course that can be done just self-study on your own online, but when through releasing the facilitator guide, it's going to be something that could be a facilitated group, either virtual or if you're back in your court and you can get together in a conference room with colleagues and kind of walk through the material together and talk about it. It would do a lot, to get those concepts to, everywhere from the front line, all the way to the bench. So I'll post a link in the conference chat.
All right. And I thought I saw one other hand come up. Roger, right next to you there.
Hi, I'm Michael Holberg. I actually work with Brady at Isles, so I don't work at a court. But one example that I have is, just really meeting people where they are. And I think the pandemic has helped that be easier with the technology we've implemented. But I guess the greatest example I can think of is the Salt Lake City Justice Court, and they took it to a completely new level where the presiding judge there took some of his staff and would actually go out to homeless encampments and work with them to clear open warrants so that they could get employment and longer-term housing. And so that...
Great example. I'm not sure how many of our jurisdictions are ready to move to that right away, but those are precisely the kind of examples that we need to hear about. We need to learn about and see if it does work somewhere, maybe it can work for us as well. There we go.
I'll just add to that. I actually do community court in Lane County, and we actually did the same thing. We called it van court. We got the library van, we partnered with them, and we hit the road out to the camps. Did the same thing. It was awesome. And at first, everybody looked at us like we were crazy and thought it was funny. And sure enough, we just did it. Things that we never would have done before. And we're really lucky. We have a provider room normally pre-pandemic at the library where we serve the community more than we even serve our community court participants. So we've really built trust in the community that way. But during the pandemic, we went out to the park blocks and had our providers come and just be available for the community, even when we weren't serving specifically our participants. But yeah, we partner with the library van and hit the road. So it was pretty awesome.
Great example. Thank you very much for that. So, and we have one from our live stream audience.
Yes, Veronica says, we have rewritten checklists and instructions into plain language so they're easier to understand.
Great example. Not always easy to do when you think about how form-driven many of our courts are and all of the work that would go into that, but anything we can do to make that accessibility easier for folks coming in and trying to use the courts to resolve whatever legal problems or disputes they have, that's going to help with the public trust and confidence. So a couple things. I'm keeping an eye on time as well, and I know we're going to run out here, but a couple of things that I just want to make sure you're aware of if you haven't heard of them before. COSCA and CCJ, the Conference of Chief Justices and the Conference of State Court Administrators, often talk about policy issues through their resolutions and setting policy for the judicial branch on a national basis. And it's important for us, I think, as court managers to be aware of some of the statements they put out from time to time. And a few years ago, they put out a statement specifically dealing with procedural fairness and the importance of that in the courts. So I just bring that to your attention for your own awareness. You can take a look at that on your own. There also another document that was authored several years ago and is available through the National Center for State Courts, and I think there have been some updates to it more recently, are Principles for Judicial Administration. This is another area that talks about more of a systemic approach to court management and ways that we can do our jobs more effectively, and by doing so, it has that natural ability to raise the level of public trust and confidence in who we are, what we do, how the general public perceives us. So there are a lot of resources that are available to us. One of the things that it talks about, and it shows another way where many of the NACM core competencies are interrelated, is that there's quite a conversation about strategic planning and visioning in the courts. There is a whole section of the core that deals specifically with vision and with strategic planning. And if you go and look at that, one of the things that you can find is that that would provide any of us as an opportunity to specifically drill down and perhaps establish public trust and confidence in the courts as one of our strategic focus areas, something that we'd want to pay attention to in a meaningful way in our own jurisdictions. You know, many of the things that we've talked about, some of the examples that have come up today, may just happen organically in different jurisdictions. But you can also manage this in a way through a strategic planning process where you can decide for your court that this is going to be a key element that you want to pay attention to and that you want to work on, and you can build that in and create a sense of public accountability for those efforts as well. So it's just something for you to think about. Another thing that I put in here as I learned about what I think are some courageous decisions that the NACM Board of Directors has recently taken to make sure that diversity, equity, and inclusion is is something that is going to be raised to a higher level in the NACM organization. It's something that we're looking at carefully. They've created a standing committee to deal with it. You've perhaps been involved in some of the sessions here at the conference this week where these issues are being honed in on a little bit more. That's just another example of programs where we can perhaps change the culture, as you mentioned, in our courts in a very positive way that is going to help our neighborhoods, the people that come into the courts, our court customers, our court users, have that higher level of public trust and confidence in who we are and what we're doing, where we're making that effort to reflect our communities in different ways and more humane ways. So that's just another area that I think is important for us to look at and consider when we're talking about public trust and confidence. As you get near the end of the curriculum itself, there's section 6 goes into a jurisdictional assessment. And this goes back to the adult learning principles that are baked into the core itself, where there's always something for you to do. There's some activity for you to get a handle on what's going on in your own jurisdiction and to look at creative ways to improve that situation. So in the curriculum itself, what you'll find is that there are assessment tools that are there where you can pick this up and you can take it back to your home court and you can start with an assessment of where you are in your jurisdiction today with public trust and confidence. And then from there, you can begin to have a better understanding of, all right, are we in a good place, a so-so place, a bad place? What do we do to improve the situation for people that are coming in to the court? It helps also to become familiar on what's going on with public trust and confidence. I'm going to be honest with you, I've done a lot of reading on this topic, but before I started to prepare for this session, I wasn't aware of how far ILS, for example, has gone recently with some of the survey work that they've been doing. Once I learned about that, I went to that session while I was here so I could get more information. Some of you are probably from states where there are access to justice commissions or justice for all commissions. Find out what's going on in your state. Have some understanding of how that might tie in to your court operation. In my state of Michigan right now, we've got a new commission that was stood up earlier this year by the Supreme Court, and it's a pretty awesome goal. They want to, the goal of the commission is to move towards 100% access to civil justice. Not quite sure how we're going to get there yet, but the fact that we're moving in that direction and thinking about it and trying to learn from other jurisdictions or other states that are ahead of us, gives us that sense of, yes, we can improve. Yes, there is a leadership in the state that is looking at how we can make the court system better for the people who need to use our services. And overall, that's going to have a positive impact on public trust and confidence. So there's lots of ideas there about how you can do your own assessment in your jurisdiction. And one thing I just learned about thanks to ICM and the Fellows program, they recently did a Fellows webinar, and one of the things that we learned through that was this new program called Just Horizons, charting the future of the courts. It's a new initiative, and I would argue, just with what little I've learned about it so far, this could have a dramatic impact on public trust and confidence in the courts, because it really looks at who we are, how we do our business. There are, one of the things identified are these 13 drivers of change, sort of looking into the future of what's going to have an impact on our courts, what's going to make us better, what kind of challenges are we going to have, how we perhaps need to leverage technology to improve our ability to cover the courts and to provide our services. So something to take a look at that I just wanted to add in there. And the last section in this competency, and I'm keeping an eye on Roger because he's watching me. He made me promise to give him 2 minutes at the end, so I can't go over time or he's going to bring out the stage hook. So the last section looks at a commitment to excellence. That's really what the focus is here. And there's a lot of information about collaboration in our community and how we do outreach to our community. There's some discussion about social media. How can we as courts do a better job using that to sort of telegraph our message to the community that we're working in, that we're here, we're a part of the community, we want to provide these services, this is how you can connect with us, whatever that might look like. And it gets back to the issue that Paul raised before about media and some of the concerns that we all probably have experienced dealing with local media, that we, and anything that we can do to improve those relationships and improve that message would be a good thing. So there's a section on that. And it ends with the, again, focusing on procedural fairness, looking at courts as problem solvers. There are a lot of surveys that we can use as a guide, but ultimately to look on what we do in our careers in judicial administration, not just as another job, but as a higher calling. And getting back to the point that this young lady made when she made her comment a little bit earlier about changing the culture and restorative justice, and the focus of the name changes that were made in your court, I think in a way goes back to some of the legacy that was set. Many of you know that we're dealing with the 50th anniversary of the National Center for State Courts. The person that was one of the people involved in there, the first president, Ed McConnell, was quoted, and I don't know if the quote's accurate or not, but I know we've used it in some NACM materials before. But he reminded us all of our legacy in the court system, and that is that courts are here and we exist to serve the public. And that gets back to the point that was made a little bit earlier. Not to serve judges, court managers, or lawyers. Everything that managers do is but a means to an end, and that end is service to the public. And that's really where we come down to with public trust and confidence. That's why it's one of the foundational or the principal layers of the core. And I just commend that to you and hope that you'll take some of these ideas and run with them, take them back to your own jurisdiction, and see where we go from here. So with that, thank you very much for taking the time this afternoon, and I'll turn the mic back to Roger.
Yes, thank you, Kevin, and let's give him a round of applause. So attached to the NACM app on this session is a public trust and confidence structured response test. So if you would please, it's a fillable form. If you open it in the NACM app, you can actually click on it. It's a little small, but you can fill that out. And there's an email address to forward that to. And after you fill it out, you press the little up arrow if you have an iPhone. I'm not quite sure how the Android one works. But it forwards it into your email, and you can return it. So we would appreciate if you would take the moment to fill that out. Also, please remember to rate the session, rate the speaker, and thank you for coming.